Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and today we're going to be talking about planning for a married couple when both spouses are in a nursing home. Last month, we talked about planning for an individual client, and we talked through a gift and annuity strategy. Today's planning is going to be similar, but we're going to be talking about how to plan for both spouses being in a facility applying for Medicaid at the same time. If you're interested in the handouts from today's webinar, feel free to download those from the handouts portion of the GoToWebinar dashboard. I just uploaded those, and if you have any questions throughout today's program, feel free to type those into the questions tab of the GoToWebinar dashboard as well. Again, my name is Amber Hines. Some of you may know me by my maiden name of Amber Gwynn. I have been working with elder law and estate planning attorneys for the last 15 years to help their clients secure Medicaid by using a Medicaid compliant annuity. I am insurance licensed in all states, and I hold a Series 65 license with FINRA as well. And I created Ashbur to assist advisors and attorneys with pre-planning solutions as well as crisis Medicaid planning solutions. How we can help you and your clients is that we provide complimentary case analysis. So we can help you to determine the optimal annuity amount, the annuity term, and which assets your clients might consider annuitizing. If your clients have IRAs or existing life insurance policies, existing annuities, we can take a look at those assets and determine if it makes sense to do a direct transfer of those assets into a Medicaid compliant annuity, or if it makes sense to simply liquidate those and use the liquidated funds to purchase a Medicaid compliant annuity. We do offer assistance from the beginning to the end of a case. So we will provide quotes if you need them. We assist with the actual funding of the annuity. And if you have a situation where one of your clients were to predecease the annuity term, we assist with the death claim process as well. If the state is listed as the beneficiary on the annuity, we will reach out to the state Medicaid agency and confirm whether there's any benefits that are owed to the state, and then pay out the contingent beneficiaries when that is necessary. We do work with A-rated insurance carriers, and we offer top-notch customer service as far as getting back to you the same day that you contact us for a proposal or with any type of question related to a Medicaid compliant annuity. To start off with, we're going to define a couple of terms. So in this webinar, we're going to be talking about two institutionalized individuals. So first, if we consider what an institutionalized individual is, or sometimes we refer to them as the Medicaid applicant, this is an individual who is receiving Medicaid funded long-term care in an institutional setting, such as a nursing home, or receiving services through a home and community-based service or a Medicaid waiver program. When we talk about a community or a well spouse, this is a spouse that is married to a spouse that is applying for Medicaid or is married to an institutionalized individual. And so usually a community or a well spouse is still residing in the home and is not applying for benefits. When we talk about a situation where both spouses are in a nursing home and applying for Medicaid, we don't have a well or a community spouse because both spouses are institutionalized. And when both spouses are applying for Medicaid, this is referred to as the Medicaid applicant or the institutionalized person. When we look at the Medicaid income and asset limitations when both spouses are in a facility, we must make sure that each spouse's total income is less than their individual cost of care. There is an exception if you are in an income cap state. If you're in an income cap state, then each spouse's income cannot exceed around $2,500 without establishing a qualified income trust or a Miller trust to get around that income limitation for each spouse. The income limitation does apply to each spouse individually. And then if we move on to the asset limitation, each spouse in most states is able to keep around $2,000 of assets. This does vary slightly depending on the state. If you refer to our website, we do list out what the asset limitations are for situations where both spouses are in a facility. For example, Ohio and New Jersey are states that say that the total asset limitation for the couple is going to be $3,000, whereas a state like Illinois, the asset limitation when both spouses are in a facility is $2,000 per spouse or $4,000 total. Either way, it's a pretty limited amount of assets that the married couple are able to retain when both are in a facility. It's usually around $3,000 or $4,000 that they can retain. Why is planning for both spouses more complicated than just traditional community spouse planning? Well, the main reason is that we don't have a community spouse that we're able to transfer without penalty most of the assets to and immediately qualify for Medicaid by doing traditional community spouse planning. So if we have one spouse that is at home and one spouse that is institutionalized, it's usually pretty easy to protect 100% of the assets by transferring around $137,000 over to the community spouse that they keep as their resource allowance, and then we can annuitize the excess resources above the community spouse resource allowance. But since in this case we don't have a community spouse that we are able to shift assets to, that's the main reason why this planning is a little bit more difficult when we have two spouses in a facility. The second reason why this planning is a little bit more complicated is because, like we just talked about, the couple is entitled to a very limited amount of assets, usually around $2,000 or $3,000 of assets between the two of them. And then thirdly, if a gift or a transfer is made, most state Medicaid agencies are going to split any resulting penalty period between the spouses equally. So what are the Medicaid planning opportunities involving an annuity when both spouses are applying for Medicaid at the same time? We're going to put together a gift and annuity plan for each spouse. In this case, we have a scenario with a married couple, Robert and Mary, where both spouses are in a facility. Robert is 80 years of age. He has Parkinson's. He resides in a nursing home. He has monthly income of $2,000 per month, and his monthly nursing home bill is $10,000. Mary, his spouse, is 75 years of age. She is ill and frail from caring for Robert for years. She resides in a nursing home as well. She has monthly income of $1,000 per month, and her monthly nursing home bill, like Robert's, is $10,000 per month. The family feels that they both could live for another 5 years in this sort of supported care environment, and they have around around $305,000 of non-IRA bank accounts between the two. First, we're going to determine Robert and Mary's monthly income shortfall or their deficit each month. Robert, as you recall, is paying $10,000 per month for his care. He has monthly income of $2,000 each month, so he has a monthly income shortfall of $8,000 each month. Mary is paying $10,000 a month for her care. She has monthly income of $1,000. So her monthly income shortfall is greater at $9,000 per month because she has less income than what Robert has. When we look at their combined monthly income shortfall or their combined deficit, the monthly nursing home is charging them a total of $20,000 per month. The couple has total monthly income of $3,000 per month, So their monthly income shortfall is $17,000 per month that they are going to be burning through their $305,000 of assets if they just continue to privately pay. With Robert and Mary's monthly income shortfall being $17,000 per month, they're going to exhaust their entire life savings of $305,000 in just over 1 year or 17 months if they continue to privately pay. Because Robert and Mary's family anticipate them living for many more years, doing nothing at all is not a great planning option here. So instead, we're going to put together a gift and annuity plan. And the goals of the gift and annuity plan is to allow a married couple with both spouses in a facility or 2 Medicaid applicants to make an immediate wealth transfer or a gift to their intended beneficiaries, and then also allow both applicants to qualify for Medicaid at the end of the ineligibility or penalty period associated to making the gift or making a transfer. As a result of the Deficit Reduction Act of 2005, in order to start a penalty period for Medicaid, both applicants must be income and asset eligible. So I like to think of the couple's assets as going into one of the 3 buckets that you see on the screen. First, each applicant is going to keep around $2,000 or less in assets. They're also going to make a gift. And then the third bucket of where the money can go into is that each applicant is going to purchase a Medicaid compliant annuity. Step 1 to determine to put together the gift and annuity plan is to determine the monthly income shortfall, which we've done already. This consists of taking the total cost of care at $20,000 per month and subtracting the total income at $3,000 per month to determine that their combined shortfall on a monthly basis is $17,000 per month. We're then going to add the monthly income shortfall of $17,000 to the divestment penalty divisor, and this is doubling the divisor for this state. This state's monthly divisor is $10,836 for an individual. Because we are dealing with both spouses that are in a facility, and the fact that the state is going to penalize the couple equally for the gift that's being made, we're doubling the divisor from $10,836 for an individual to $21,672 for this couple. We determined that the total burn rate in this case is $38,672. What is the divisor and where can you find it? The divisor is the number that Medicaid uses to calculate the penalty or ineligibility period by dividing the amount that is gifted or transferred by the divestment penalty divisor. The penalty divisor is a number that Medicaid considers to be the average cost of 1 month in a nursing home in your state. So this is going to depend, the number is going to depend on where you live geographically. When we work in states that are in the Northeast area of the country, this number is going to be anywhere between $10,000 and $15,000 per month. And then if we are working in a state like Georgia, where I'm at, the average cost is going to be a lot lower, at around $6,500 per month. Texas is even lower than that. So this is going to depend on where you live as far as what the penalty divisor is in your state. If you're unsure or you need to find what your divisor is, you can either find that on our website, or a lot of states publish that number in their state Medicaid manuals as well. In this case, we doubled the divisor because we have 2 Medicaid applicants, and in most states, Medicaid is going to split or apportion the penalty period equally between each spouse. we're going to look in the Medicaid manual to look for language, something along the lines of if both spouses are in a penalty situation, the penalty period or any remaining part must be divided equally between them. The third step after we have determined the burn rate is to determine how long the penalty period or the time frame of the plan is going to be. We're going to do this by dividing the total countable assets of 305,000 by the burn rate of 38,672, and we determined that the term of this plan is going to be 7.88 months. We would then round the 7.88 months up to an 8-month time frame and multiply the 8-month time frame by the double divisor of 21,672 to determine that the immediate gift amount in this case is going to be $173,376. After we determine the gift amount, we would then determine how much is going to be available of the $305,000 to purchase a Medicaid compliant annuity to be able to privately pay for the nursing home during the 8-month ineligibility period. And we're going to do that by subtracting the gift amount of $173,376 from the total countable assets of $305,000 to determine that the annuity amount is going to be $131,624. The total amount that is going to be used to purchase the annuity is $131,624. In this case, we would need Robert and Mary to each purchase a Medicaid compliant annuity for each spouse because we would not have the ability to do a jointly owned Medicaid compliant annuity in most states. And so we then have to determine how much of the 131 is going to be used to purchase an annuity for each spouse. And here we're going to refer back to our individual monthly income shortfalls that we started out the presentation talking about, where Robert has around $1,000 a month more of income than what Mary has. So he has a lesser monthly income shortfall at $8,000 per month. Mary has a greater monthly income shortfall at $9,000 per month when we compare their cost of care and what their income is. So when we're deciding how the 131 is going to be split between these spouses, Mary is going to have a larger annuity purchase than what Robert would have because she has a greater income need than what he has. We have to keep in mind that we are trying to not create exactly the amount of income that would be necessary for each of them to pay for their nursing home so that we still have a monthly income shortfall for each of these spouses when the annuity is purchased. You'll notice on the screen here that each annuity, Robert and Mary's annuities, are both purchased for 8-month time frames. Robert's annuity is being purchased with $62,000 for an 8-month time frame, which is creating monthly income of $7,760 per month. The total payout is $62,080 per month, which is slightly greater than the amount going into the annuity, which is the small amount of interest that would be paid on the annuity. Mary's annuity is going to equal $69,624. Her annuity is also being purchased for 8 months, and the monthly payout is $8,710 per month for a total payout of $69,680. You'll also note that an annuity can only be structured for a whole number of months. We can't purchase an annuity for 7.88 months, it would have to be either a 7-month annuity or an 8-month annuity, which is why we rounded the penalty period up to 8 months. And we also are purchasing the annuity for an 8-month time frame as well. If you add up the 62,000 and the 69,624, that is equaling the $131,000 total that we had to purchase the 2 annuities, one for Robert and one for Mary. During the penalty period, Robert's monthly income is going to be his Social Security and income of $2,000 per month, plus his annuity income that we just talked about at $7,760. His total income then equals $9,760 each month. His shortfall is going to be determined by taking Robert's cost of care at $10,000 per month and subtracting out his total annuity income and Social Security at $9,760 to determine that his monthly income shortfall is $240 each month. During the penalty period, Mary's total income is going to consist of her Social Security at $1,000 plus the annuity income at $87.10, so that her total income is going to be $97.10. During the penalty period, her shortfall is going to be $290 each month, and this is determined by taking her cost of care at $10,000 and subtracting out her total income at $97.10 to determine that her shortfall on a monthly basis is $290. Many people ask us why there must be a monthly income shortfall when we determine the annuity amounts. And in order to establish that a Medicaid applicant is otherwise eligible for Medicaid, we must spend them down and make sure that they are resource and income eligible. If we were creating exactly the amount of income that the Medicaid applicants needed to pay for their nursing home, Medicaid is not going to start the penalty period associated to making that gift because they would not be income eligible, which is why we have to establish that there is a monthly income shortfall between the annuity, Social Security, and any other income sources, and also what the cost of care is. The economic results of the gift and annuity plan is that the couple was able to make an immediate wealth transfer or a gift of $173,376. Robert and Mary were both ineligible for Medicaid for the 8-month private pay or penalty period. Robert had total income during the penalty period of $97.60, with his nursing home costing $10,000 per month. He had the monthly income shortfall of $240, and Robert would become eligible for Medicaid in the 9th month. Mary had total income of $97.10 during the penalty period, with her nursing home costing $10,000 per month. She had a monthly income shortfall of $290, and she also would become eligible for Medicaid in month 9. Many people will ask us how the monthly income shortfall of $240 and $290 would be paid, and this is really going to depend on how large the monthly income shortfall is. In most cases, it can either be paid from the assets that Robert and Mary would keep of the $2,000 or $3,000 of assets. Otherwise, if that's not enough to cover the shortfall, then a portion of the gifted money would need to be used to pay for the income shortfall if the resource allowance isn't sufficient to cover the shortfall. Robert and Mary's children received an immediate gift of $173,376, which is more than 50% of the $305,000. And Medicaid is going to start paying for Robert and Mary's care in month 9. The disadvantage of doing the gift and annuity plan is that if Robert and Mary don't live through the 8-month private pay or penalty period, they would not have gained any economic benefit from Medicaid, because Medicaid is not going to start paying for their care until the 9th month. So in all of these cases, life expectancy is going to be a factor as to what is the best option or situation for proceeding for clients as to whether we do a gift and annuity plan or just privately pay and not do this type of spend down. The annuity parties on Robert's annuity, he is going to be the annuity owner, the annuitant, and the payee. The state Medicaid agency is likely going to be the primary beneficiary to the extent that they would provide Medicaid benefits on behalf of Robert. There are some exceptions to the state being named as the primary beneficiary. If they have a minor or disabled child, they could be listed before the state Medicaid agency. And then the contingent beneficiary in most cases is going to be the children, a trust, or a charity, whoever they want to name as the remainder beneficiary after the state. Mary's annuity is going to be set up the same way, where she is the annuity owner, she's the annuitant, and the payee. She's going to be receiving the payments from the annuity to pay for her nursing home during the 8-month private pay period. The state, again, is going to be the primary beneficiary, and then the contingent beneficiary is going to be children, a trust, a charity, or whoever they want to name as a remainder beneficiary. Let's assume that Robert passes away 6 months after the annuity is purchased. What is going to happen to the Medicaid compliant annuity? With the state being named as a primary beneficiary, we would need to reach out to the state Medicaid agency and confirm whether they provided any Medicaid benefits on behalf of Robert. In this case, since the annuity is being used to privately pay during a penalty period, the state likely is not going to be owed anything from the annuity. And so Robert's children would be a secondary beneficiary. They would be able to receive whatever is remaining in his annuity if he were to pass away 6 months into the annuity, when the annuity is structured for an 8-month time frame. Some states will add the remaining 2 months of penalty that Robert did not serve over to Mary's penalty period. If this is the case, then most of the time the secondary beneficiary, the children, would have to be aware that they're going to use some of the annuity payments from Robert in order to privately pay for 2 additional months of penalty that Mary would have to serve. When Robert passes away during the annuity term, with Mary's initial penalty period being 8 months, the state may extend her penalty period for an additional 2 months that Robert did not serve, which would result in a 10-month penalty. And so, like we just talked about, if there are additional months of penalty, then the remaining amount of Robert's contract may need to be used to pay for the additional months that Mary would need to serve of a penalty period before the state is going to start paying. If we instead assume that Robert passes away 12 months after the annuity is purchased, what's going to happen to the annuity? Absolutely nothing, because Robert's annuity was purchased for an 8-month time frame. So it's going to be done paying out within 8 months. And so Robert passing away in month 12 is not going to have any impact on the annuity because the annuity is done paying after an 8-month time frame. When we look at the time frame to implement a gift and annuity plan, we're usually going to have the couple make the gift, purchase the 2 annuities, and apply for Medicaid all in the same month. And we do this to establish that the applicants are otherwise eligible for Medicaid, but for the gift or the transfer, meaning that they have spent down to the allowable asset and income limits in order for Medicaid to start the penalty period. Once the Medicaid application has been submitted, Medicaid is going to determine the penalty period associated to making the gift, in this case of the $173,000. We're going to use the annuity payments to pay during the 8-month penalty period. And after that 8-month penalty period is over with, then Medicaid is going to start paying in month 9 after the penalty period is over. How does the plan change if the applicants are residing in an income cap state? Really, the plan is going to remain exactly the same, other than the income for Robert and Mary are going to have to flow through a Miller Trust or a qualified income trust, because the current income limitation is around $2,500 per month. And we know that each spouse in this case had more income than the 2,500. And so the annuity income and potentially the other income from Social Security are going to flow through the qualified income trust or the Miller Trust before paying the nursing home, in order to establish that each of these individuals are income eligible for Medicaid. On the screen here, you're seeing all of the states that are considered to be income cap states. The states that are in orange, you would need to establish a qualified income trust for a case like this, because the couple's income is exceeding the $2,500 per spouse. 2 alternatives to a gift and annuity plan would be a gift and promissory note. Instead of using an annuity for an 8-month time frame, if your state does allow for the use of promissory notes, you could do a note for 8 months for each spouse in order to create income to pay for the penalty period of 8 months. The math is going to be very similar, other than the fact that a note would be used instead of an annuity. The other option is a gift in return or a partial cure, which means that basically the $305,000 would be completely gifted in the beginning, and then each month the children in most cases are going to return a portion of the gift to the Medicaid applicants, and after approximately half of the money is returned to the Medicaid applicants, then you would reapply for Medicaid and have the penalty period adjusted based on some of the money being returned to the Medicaid applicants. You'll want to make sure that your state honors a partial cure before implementing that type of planning, just because some states don't like seeing the promissory note, and some states are not really okay with doing the gift in return strategy or partial cures either. If we consider a fact change or the timing of each spouse needing care, how does the plan change if one spouse is already on Medicaid and the second spouse later needs care and needs to apply for Medicaid? Some states in this situation will only apply the penalty period to the second spouse that is making a gift, In that case, only one annuity would need to be purchased because the first spouse is going to remain on Medicaid uninterrupted without having to purchase a second annuity and have the first spouse come off of Medicaid. Whereas other states are going to apply the penalty period equally to both spouses, like the plan that we just talked about. So in other words, if a gift is made by the second spouse that enters the facility, then we're going to split the penalty period equally, like we talked about in this presentation. And so this is what we find that most states do if the second spouse goes into a facility and needs to apply for Medicaid after making a gift, is they're going to split that penalty period equally between each spouse. And so the first spouse comes off of Medicaid and you would be doing two separate annuity purchases. You'll want to look in your state Medicaid manual to see if there is language in there as to how a state is going to excuse me, how a state is going to handle spouses sharing in a penalty. The language that I included on the screen is from Michigan's manual that talks about splitting penalty periods and what happens if one spouse is already in a facility on Medicaid and the other spouse has to then apply for Medicaid after the fact. And so you'll want to see how your state addresses a penalty period, both when spouses are applying for Medicaid at the same time, and then if you have a situation where one spouse is already on Medicaid and the second spouse has to then apply and they're making a gift. In summary, the timing of the plan is going to be everything. Are both spouses applying for Medicaid at the same time, or is one spouse already on Medicaid? That's going to be important as to how your state will assess what the penalty period is. And then also we would be looking at the couple's longevity. If one spouse does predecease the penalty period or the annuity term, some states are going to add the resulting penalty period to the other spouses or to the surviving spouse's penalty. So those are two important items to consider when doing a plan for both spouses in a facility. And now I will take any questions that people have. We have a question here from Oregon. So would we need to do a gift and return strategy for each spouse? And the answer to that would be yes, because Oregon has a actuarially sound test on the annuity, meaning that the annuity must pay out within 12 months of the life expectancy of each spouse. And so in this case, we would not have that 12-month time frame to deal with. So you would be doing a gift and return strategy for each spouse if you have both of them in a facility in Oregon. We have a question here in alternative 2, if spouses already on Medicaid, where would the funds come from to pay for the additional penalty? I think you're referring to a situation where one spouse is already on Medicaid, and I was talking about making an additional, the second spouse needing to go into a facility. And so the only time that the first spouse would have to come off of Medicaid would be if you were having the second spouse make a gift and the state penalizes the gift that the second spouse makes equally between the two of them. But if you have one spouse that's on Medicaid and the second spouse doesn't have any assets and they're not making a gift, then you don't have to worry about where the additional funds are going to come from, because that private pay period would only apply if they are making a gift or a wealth transfer out of their names. Okay, it looks like I answered that question. I'm not seeing any other questions here, but if you do think of questions from today's webinar, you can reach out to us by phone using the phone number that's on the screen or by email. And I want to thank everybody for joining us today for today's presentation. Next month, we're going to be talking about just traditional community spouse planning. So that's going to be a little bit more relevant for clients where one spouse is in a facility and the other spouse is remaining at home, or we have a community spouse. And so if you have any questions, feel free to reach out either by email or phone. And again, thank you for joining me today, and everybody take care. Happy Easter.